Honorable Onyina, one question from me.
Yes, my lady.
Our constitution guarantees freedom of movement and right to human dignity. Some time back, the government decided that we needed to relocate refugees from urban areas and take them to a place other than being in the urban area, like for instance Kakuma refugee camp. Now, one of the refugees from that camp institutes a case and says there has been a violation of my freedom of movement as well as right to human dignity, because as it were, we are being asked to relocate and to be confined to a refugee camp. And of course, he says, he cites the various provisions of the Constitution that speak to the issue of freedom of movement and right to human dignity. Remembering that this refugee is not a Kenyan citizen and the matter comes before your court, how do you think you'll handle such a matter?
Thank you, Commissioner. Freedom of movement is a guarantee that is provided and is to be enjoyed by each and every person. And when it comes to refugees, we have applicable laws that govern and also govern the operation of matters to relating to refugees, and also make available to them particular rights. And those laws include the 1951 United Nations Convention on Status of Refugees, as read together with its 1967 protocol. We also have the 1963 OAU Convention on specific aspects of refugee problems in Africa. They provide for different categories of rights.
So are these part of the Kenyan law?
They are part of the Kenyan law in line with the provisions of Article 2, Sub-Articles 5 and 6 of the Constitution of Kenya.
That's correct. But I'm waiting for your determination.
Yes, if a directive is given that the refugees are supposed to put up at a particular location only within the Republic of Kenya, that would be a violation of their right, freedom of movement, and the rights guaranteed under the 1951 Convention on Status of Refugees.
Thank you. That is correct. Secondly, there is a matter that has come before you, and one of the prayers that is being sought is that a declaration be made that we are entitled to a clean and healthy environment. And assuming that you are sitting as a High Court judge, which again, under the Constitution, you have unlimited original jurisdiction. Tell us what you will do with a matter that has a prayer seeking an order for a clean and healthy environment.
Thank you, my lady. Under Article 162 of the Constitution of Kenya, there are courts established that are of equal status to the High Court. One of them is Environment and Land Court. When I have such a matter before me, I would go through the pleadings and seek to understand so that I get to know the dominant nature of the claim. If the dominant nature of the claim is such that the matter should be heard before the Environment and Land Court, then I would say that I do not have jurisdiction, that jurisdiction having been specifically vested in the Environment and Land Court. Thank you, my lady.
Thank you. That's all, Honorable CJ.